Welcome back. Thank you for staying with Checkpoint. We continue informing you. Now, just before the break, we highlighted a story touching on the 2 years of Kenya Kwanza administration, where our reporter Vera Mora focused on the love-hate relationship between the executive and the judiciary. So right now, we want to evaluate that relationship with a member of the judicial arm of the government, Manwa Hosea, who's an advocate and a council member of the Law Society of Kenya, joins us via phone just to give us his take on a raft of issues that touch on that love-hate relationship between the executive and the judiciary. Manwa, a very good evening to you and thank you for making time. First things first, President Ruto's firm grip on the August House has actually enabled him to pass some of the policies and legislative pieces smoothly, although he has faced opposition in the corridors of justice. Now, some think the judicial opposition is due to judicial activism, while some others pointed towards the government or lack of advice towards the government through the office of the Attorney General. In your view, why is it that some of the Kenya Kwanza policies have been contested time and time again in court, bearing in mind ignorance of the law is no excuse in this particular case?
Thank you so much, Jesse, for having me. First and foremost, it's very important for us to establish why the court is making the decisions that it's making on those legislations, pieces of legislation that have been filed in court. And I think it's important to understand the mandate of the Attorney General and Parliament. And I think if you've looked at all those cases that have been filed, you start with the housing levy, the finance bill, the deployment of KDF, the SHIELD, the Maisha number, and even protest cases, you will notice one common denominator, that there was no proper public participation. And this proper public participation is supposed to be done in Parliament. Parliament has a duty to legislate, oversight, and represent. And so if they fail to conduct themselves in that space and perhaps ensure that those pieces of legislation go through proper participation, then obviously you'll expect that the pieces of legislation after being passed will be challenged in court. And that is what has been happening throughout this government regime, because they have failed to conduct proper participation, public participation, and actually the court has pronounced itself time without number that for you to pass such legislation, especially those 3 or 4 pieces of legislation that touch on health, that touch on the finance bill generally, the deployment of KDF and the housing levy, they touch every citizen of this country. And there was a duty in Parliament to ensure that they follow that process to the latter.
Okay, proper public participation. That's my takeaway on that particular point. But moving on, the Kenya Kwanza administration took power with the promise that the government would no longer disregard court orders. We've seen instances where the government follows the law to the letter, but equally numerous instances where there's utter disregard of court orders. From your point of view, is the government walking the talk, or are court orders no longer imperatives?
It's important to note indeed that when the President of the Republic of Kenya, when he came into office, he actually showed good faith by ensuring that he swears in the 6 judges who had stayed over 2 years after being appointed by the Judicial Service Commission, and proceeded and actually appointed them into office. It was a good gesture and for the rule of law. We had an expectation that this could be the trend going forward. But obviously we have listened to utterances that go against that indication that he made initially. Of course, the judiciary will always be on the receiving end, especially when they do their work. Remember, all the decisions that we have witnessed from the court has pronounced itself on the law. And the court is not fighting the executive. It is actually each of the government branches making decisions based on the mandate they have been given. Under the principle of checks and balances, the judiciary has a duty to check excesses of the executive, and by nullifying those pieces of legislation, it's the judiciary asserting its position and actually ensuring that the rule of law is followed. So there is never a good time for both the executive and judiciary to be on the same page, because they actually act on opposite sides of the Constitution. And by doing so, obviously, we expect that the relationship will not be a relationship that is a friendly one. We'll expect the executive to always, of course, claim that the judiciary is employing judicial activism or making decisions that sabotage the executive and also. But I believe that if you read those decisions of the court, you will understand where the court is coming from. And it's time that we blame the right people. Parliament has failed on its duty. It's Parliament that is supposed to ensure that they do their work. They have failed. We have the Office of the Attorney General, who is supposed to advise the executive and the president as to the decisions of the courts and of course on those pieces of legislation. Look at what is happening with Adani. Did the Honorable Attorney General go through those documents before he or she, depending on who was in office at the time, allowed the government to get into a situation where we can lease our airport for 30 years? So those are the concerns that we have, and we expect that those two offices, the Office of the Attorney General, who is the official advice of government, and Parliament, to take responsibility for failing the people of Kenya, especially when it comes to these issues.
All right, Manwa Hosea, thanks for your time and your indulgence in that particular topic. He's an advocate and a council member of the Law Society of Kenya, just speaking his mind on the hits and misses on the Kenya Kwanza administration in regards to its relationship with the judiciary, which is an independent arm of government. According to him, proper public participation should be enacted upon, and equally the legal advice